Once upon a time in a small southern town in the United States lived a young black girl named Amina Johnson whose voice carried an accent. A cadence not native to the sleepy streets and red brick schools of her hometown, an accent shaped by the melody of her immigrant mother's first language, an accent that her white classmates weaponized against her from the moment she walked through the doors of first grade. They mocked the way she said water and paper, called her exotic, slow, illiterate, whispered behind their hands that she sounded like an outsider, and at recess they mimicked her, imitating her vowels until she shrank into herself, retreating into silence, avoiding lunch tables and group projects, feeling the weight of their stares and sneers as though she were carrying the burden of unworthiness. But even as she developed anxiety, trembled when called upon, and lost friends, Amina's parents reminded her, "Your voice is your heritage, your accent is a story, don't lose it." In middle school the bullying escalated. Peers in her homogeneous school used her accent and race as signs she didn't belong. Research shows that racial and linguistic bias increases bullying rates for minority students, often linked to stereotypes about foreignness or educational inferiority. Amina felt that more than most, her black identity already marginalized in the majority white community, layered with a non-standard accent. In classrooms teachers sometimes excused the behavior or chalked it up to kids being kids, even when her mother tried to intervene. Amina stopped raising her hand, she stopped raising her voice, she carried notebooks filled with new words she'd learned from school readings, determined to master standard English pronunciation. But every correction felt like erasure of her origin, and every practice in front of the mirror echoed with past humiliation. Despite the bullying, Amina excelled academically, math, history, writing, becoming known for her sharp mind if one listened past the accent. But many wouldn't, and her classmates whispered that she didn't sound black. Scholars describe this as interracial bias, black youth who defy stereotypes, academic success, being friends with white peers speaking standard English, can face backlash from peers accused of acting white, making them targets even within their own group. Amina felt the sting from both sides. She wrote in her journal that by the time she reached high school, she had mastered a version of her accent more palatable to the majority, yet never rid of it entirely. She applied to elite summer programs in Washington, D.C. and New York, driven by ambition and the memory of taunts. At one national mock trial competition in D.C., she stood, trembling before a room full of students from private schools. One judge interjected mid-opening that they couldn't understand her pronunciation. But Amina took a deep breath and carried on, argument structured, powerful, evidence compelling. The later rounds became electric. Judges praised her legal reasoning, classmates sought to work with her, and suddenly the same voice they had once mocked earned respect. This echoed real experiences of many black professionals in elite fields today who face microaggressions at work despite competence and credentials. Amina returned home a changed person, not free from insecurity but galvanized. She won a full scholarship to Harvard Law School. In Cambridge she immersed herself in international law seminars and human rights clinics, representing asylum seekers, teaching legal literacy to immigrant girls with accents like hers. Yet the memory of her classmates' laughter didn't fade. She confronted it again in study groups, where peers cringed at her phrasing, asked her to speak more clearly, as though clarity were separate from identity. She responded by mentoring other students from under-resourced high schools, teaching them to use their voice not despite their accent, but because it carried their vision. Her journey drew the attention of legal journals and campus newspapers as the accented scholar rewriting justice. She interned at a prominent international NGO in New York, analyzing cases involving refugee rights and linguistic discrimination abroad. At one firm roundtable, a white partner asked, "How do you shift from your accent to American English?" Amina replied, "Why should I shift? I speak the language I speak because language is power, and I will teach others how to use their own." Her voice became an asset in public speaking engagements, conferences on diversity in law, and panels advocating anti-racist education in U.S. schools. She began writing about how bullying based on accent and race is a form of racially motivated harassment, linked to elevated risks of depression, school avoidance, and academic decline in youth of color. Amina also connected stories of students like her to broader patterns of linguicism visible even in artificial intelligence face recognition and hiring tools biased against African American English speakers. After law school she accepted a prestigious postgraduate fellowship at the United Nations in New York, working on immigrant justice issues. She traveled across continents, advising governments on language rights, culturally competent legal systems, and protections for non-native English speakers. But her true breakthrough came in a case rooted in the U.S. She represented a black immigrant woman who had been fired from her healthcare job because supervisors claimed her accent made her unprofessional, even as her performance metrics exceeded all expectations. Amina argued before the Equal Employment Opportunity Commission that firing someone for accent-based assumptions constituted racial discrimination under Title VII and linguicism rules. She won a landmark ruling. The EEOC found her client had been discriminated against based on language prejudice tied directly to race. The ruling was hailed in national press as precedent-setting for linguistic justice in employment. Amina's client became a symbol for millions of Americans with accents who face subtle bias. In the media she was called the lawyer who made her accent her cause. She founded a nonprofit, Voices of Justice, advocating legal rights for speakers marginalized due to race and accent. She launched mentorship programs pairing law students from small towns, especially black girls with accents like hers, with attorneys. Her childhood bullies were now powerless, and she toured universities telling her story, how their laughter once nearly silenced her, how she turned mockery into motivation, and how the law became her tool for systemic change. Yet even as her fame grew, she felt tension between public persona and private hurt. One evening, launching a grant in her hometown to fund speech and identity workshops, she faced the parents of those former classmates in a packed gymnasium. They whispered and glared. She felt the weight of their unspoken shame. She realized her success had unsettled more than just her bullies. It unsettled a culture that demanded assimilation, silence, and shame. She remembered the young black boys who had called her worthless because she did not sound stereotypically ghetto or black enough, as documented in real school stories where some black girls are bullied by black boys who themselves reinforce misogynoir and self-hatred in their peers. Amina spoke about how racial bullying in school is often dismissed as intragroup dynamics, but in fact it is rooted in misogynoir and systemic racial hierarchies. She ended her speech with, "Your laughter nearly stole my voice. I reclaimed it, not just for me but for every girl whose voice was stolen." That night, applause thundered, but inside she feared what might follow. Because the same patterns of dismissing accent prejudice continue across sectors. And because her case had set a legal precedent, eyes from corporate America, government agencies, and even AI developers were watching. A month later, while preparing a high-stakes international arbitration over linguistic rights for indigenous communities in the Pacific, she discovered a confidential report showing that a multinational corporation had secretly manipulated language requirements to exclude black and indigenous applicants, effectively denying them access to contracts. The evidence mirrored the systems of exclusion she had overcome and knew intimately. As she stared at the encrypted document on her screen, she felt every childhood taunt echo in the silence of that late-night office, realizing she had the power to bring justice, but also to expose how deep racism and language policing run even at the highest levels of global business. And as she clicked to open the file, the lights in her office flickered, and a notification popped up. Class action suit filing deadline tomorrow. Your firm needs your argument ready by 8 a.m. Don't forget to like, comment, and subscribe for more powerful stories that uplift black voices and expose hidden truths. Once upon that early morning after her breakthrough in the EEOC case, Amina Johnson awoke in her D.C. apartment with the memory of courtroom cheer echoing, and yet she felt an ache at the edge of her triumph because a deeper fight had just begun as she prepared to represent clients in a new legal controversy tied directly to accent-based and racial bias. The ruling she had won had set precedent. Title VII prohibits discrimination based on accent unless the employer proves the accent materially interferes with job performance, and most courts require a very searching look at any adverse decision tied to accent because linguistic trait is inseparable from national origin and race, and even a heavy accent used as pretext or mockery may constitute actionable discrimination, as seen in cases like West Customer Management Group where the 11th Circuit allowed a candidate to pursue a claim after hearing remarks about a thick accent despite inconsistent testimony. Amina leaned on those legal foundations as she drafted a narrative for a major new client. A black immigrant woman terminated from a banking job after coworkers and a supervisor repeatedly mocked her accent, claimed she lacked professional presence, even though performance metrics exceeded expectations, and when she raised complaints, human resources dismissed her concerns as cultural adjustment. Amina saw in her client's story echoes of her own childhood, the sting of sibling whispers of classmates saying she didn't sound black enough, the painful layering of racial and linguistic prejudice. Federal guidance clearly classifies accent-based harassment as national origin harassment under Title VII if it is severe or pervasive. Employers cannot rely on discomfort or bias of coworkers or clients to justify adverse action unless they can show the accent materially interfered with work duties, and such mockery may be actionable even if the speaker is technically understandable. As Amina prepared her EEOC charge and potential lawsuit, she studied landmark litigation. Carino v. University of Oklahoma affirmed that firing someone for a Filipino accent constituted discrimination when no impairment existed and accent was inextricable from origin. Ferganti v. Honolulu upheld denial only when accent materially interfered with phone communication in public-facing roles. Those distinctions shaped her strategy, to show her clients' English communication was clearly effective, and that manager remarks reflected bias, not bona fide business necessity. While filing the case in D.C., she reflected on her own journey, from bullied black girl in a southern town to international law school, human rights clinic, and the first case she won before the EEOC setting linguistic precedent. She also thought of academic work confronting bias in AI systems that downranked African American English or non-standard speech, and how courtroom demeanor is too often coded language policing, tools of systemic racism that reward assimilation over authenticity, and she resolved this case would push back. At the same time, Amina encountered backlash when she filed a class action on behalf of multiple plaintiffs across several states, all fired or disciplined due to accent and language-based assumptions tied to race. The defendant corporation tried early dismissal, arguing performance concerns, not bias, justified termination. Amina rebutted using comparator evidence, showing white employees with similar communication styles, or even heavier regional accents, were retained, citing the burden-shifting framework from McDonnell Douglas to prove prima facie discrimination. Back at the office each day she carried documents, court filings, deposition outlines and witness statements. Yet fatigue set in, legal motion deadlines, client anxieties, media calls. National outlets wanted her commentary on the new wave of linguistic justice cases. The intersection of race and accent was becoming timely. Some commentators compared her cases to historical Title VII battles over racially coded traits like natural black hairstyles, such as in Rogers v. American Airlines, where the court grappled with whether cultural, immutable traits deserve Title VII protection, and Amina's legal team argued accent too must be protected, as a core national origin characteristic tied to identity and race. Then came a breaking moment. During depositions, the defendant's HR lead admitted under oath that she had complained internally about workers who didn't sound right, saying, "We need our staff to speak how customers expect," a clear signal of bias. Amina seized that admission, moving for class certification on national origin discrimination grounds. But just as momentum peaked, her firm's senior partner called her into a conference room. In hushed tones, he said corporate clients had pushed back, expressing fear that speaking out would lead to broader litigation across industries on accent-based claims. He warned her, "You're shaking the boat. They don't like it." And soon after, internal whispers circulated. Her activism was too radical, her cases too political, and partners began distancing themselves. Yet Amina's conviction did not waver. She held town hall-style meetings with advocacy groups, shared her own story of accent bullying as a black child, spoke of how linguistic discrimination reinforces racial exclusion in schools, workplaces, and justice systems. She saw law students lining up to intern with her firm Voices of Justice initiative, driven by her example. Still, as her public role grew, so did tension behind closed doors. One late Friday afternoon, after sending filings for summary judgment, Amina learned. Her managing partner had informed the firm's ethics committee that her class action strategy, ignoring internal pressures and filing for system-wide reform, risked reputational harm. They were contemplating disciplinary action. Amina sat at her desk, eyes stinging, heart pounding, as she realized success meant scrutiny. She forwarded the deposition transcript where HR admitted bias to the EEOC as new evidence. An hour later her phone buzzed. An email subject line read, "Request for meeting, firm ethics hearing." At that same moment, another alert popped up. Her client from Georgia, whose firing story she had featured in a media interview, had received an EEOC right-to letter confirming the commission would move forward with enforcement. The plaintiff's case stood a chance to become national precedent, but Amina now faced potential sanction from her own firm for championing it. She stared at the two threats side by side: public vindication and private peril. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths. Once Amina Johnson emerged triumphant in her EEOC case and survived backlash from her law firm, she shifted focus to expanding the fight. She filed a nationwide class action suit under Title VII on behalf of Black and immigrant employees across multiple states who had been fired or marginalized because of unfair judgments about their accents and national origins. She grounded the case firmly in legal precedent. Title VII bans discrimination based on accent and linguistic traits tied to national origin, including offensive remarks and adverse actions, regardless of whether the employee's speech materially hindered job performance, as detailed in EEOC enforcement guidance and legal scholarship illustrating how accent-based bias falls squarely under national origin protections. She invoked comparator evidence showing white employees with strong regional or foreign accents had not faced discipline, using the McDonnell-Douglas burden-shifting framework to establish intentional disparate treatment. Amina cited appellate decisions recognizing accent claims, including West Customer Management Group, to bolster her case that mockery of distinctive speech, even if intelligible, can amount to actionable harassment. She also referenced scholarly legal commentary arguing that systemic prejudices like appellation or non-standard Black speech have historically been denied protection despite fitting within national origin categories. As she prepared the complaint, she traveled across states to interview clients and gather depositions. One testimony stood out. A Black bank teller from Georgia recounted how a manager ridiculed her accent in front of customers, saying she didn't sound professional, despite her error-free record. With meticulous care, Amina ensured each affidavit tied hard data, performance reviews, call recordings, deposition transcripts, to the narrative of racial linguistic bias. Back in the office, the pressure mounted. Senior partners and corporate clients raised concerns that the class action might threaten existing relationships and expose widespread practices beyond her firm's control. Rumors circulated that she was too aggressive, too outspoken, a danger to the firm's conservative reputation. But her nonprofit wing, Voices of Justice, lit up with donations and requests for help. Law students and early career lawyers volunteered to support her campaign. She held webinars on language justice, anchored legal literacy clinics in underserved schools, and reinforced her personal story, how a young Black girl from the South had been silenced by racialized accent shame, but reclaimed her voice in courts, boardrooms, and international fora. Meanwhile, media coverage reached a crescendo. Legal news outlets dissected her case as a watershed moment for linguicism and racial inclusion. They contrasted the civil rights battles over natural Black hairstyles and cultural dress, such as Rogers versus American Airlines, with the emerging frontier of voice rights, demanding that accent-based stereotypes be recognized like any immutable trait of race or national origin. At oral argument before a federal judge in D.C., Amina delivered a powerful opening. She called national origin discrimination an invisible code of exclusion that punishes people of color for sounding outside white norms. She cited EEOC guidance reaffirming Title VII's protection of accent and ethnicity, even when no performance harm is shown. When opposing counsel claimed customer discomfort justified terminations, Amina pointed to decades of E-Race initiative statistics showing that EEOC rejects customer preference as a defense, especially when it masks racial bias. Just as momentum seemed unstoppable, Amina received devastating internal news. Her firm's ethics committee had convened and was considering disciplinary action, citing her refusal to heed partner counsel when she pursued the case aggressively despite client concerns. She was warned she might face sanctions for disobedience, even though her actions aligned with Title VII and EEOC precedent. Simultaneously, an EEOC investigation in a separate matter began identifying her class action as systemic discrimination. If substantiated, the EEOC could file its own enforcement suit, stepping in to represent hundreds of affected workers with its full legal power. Amina welcomed this, but it carried risk. Federal action would intensify scrutiny, make the case national and partisan, and trigger backlash from anti-DI advocates aligned with current EEOC leadership. which under Trump's appointee has signaled hostility toward diversity programming. Amina now faced the extraordinary dual reality: unprecedented legal leverage on behalf of thousands versus professional risk from her own firm and political backlash. Late one night she stayed in her office, reviewing deposition transcripts and evidence logs. Files and flash drives scattered across her desk, bearing notes, audience statements, mock interview clips. She realized there was a turning point coming, a decision that would define not just this case but her legacy. Just then her phone buzzed, an email notification from her managing partner titled, "Urgent. Your firm attendance required, time to discuss your direction." At the same time, a second email arrived from the EEOC investigator assigned to the systemic probe. "Request for coordination. Do you plan to testify under oath?" Amina stared at both subject lines, heart pounding. She recognized that she must soon choose: double down publicly and risk being disciplined, or step back and let the cause become broader but detached from her leadership. She drew in a breath, fingers hovering over the reply button. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths. Amina Johnson returned to the firm feeling the weight of dual conflicts. On one side, her class action and EEOC tactics were gaining momentum. On the other, her own firm's leadership was viewing them as liability. She reviewed federal precedent, across both national origin and race protections under Title VII, that supported her strategy. The EEOC and courts have long interpreted accent-based mockery or bias as national origin discrimination, even if the accent did not impair job performance, including large settlements like nearly $1 million for accent harassment at a California medical center. She also relied on employer obligations under disparate treatment doctrine, as described in EEOC guidance, prohibiting both adverse actions and toxic work environments rooted in racial or linguistic stereotypes. And she drew from scholarship arguing that refusing to accommodate accent while permitting similar communication styles among others reveals selective non-accommodation and signals intentional disparate treatment. At a critical juncture, Amina's federal complaint survived a motion to dismiss. Her client depositions, Black and immigrant professionals fired for sounding wrong, despite strong job performance, combined with internal HR statements revealing bias, constituted a plausible claim under Title VII. The court agreed to certify a national class, allowing the case to move to discovery. She and her team prepared for depositions of supervisors across multiple states and drafted motions leveraging McDonnell-Douglas burden shifting to show prima facie disparate treatment followed by employer failure to rebut. She also stayed abreast of legal developments, including a recent U.S. Supreme Court decision reaffirming that Title VII's standard applies equally to majority and minority group plaintiffs, eliminating any raised evidentiary threshold based on background circumstances. But inside the firm, the atmosphere shifted. Major corporate clients began pressing partners, warning that Amina's litigation might trigger a wave of similar claims in their industries. Some partners quietly suggested she tone down public appearances. Others questioned whether her mentorship and public speaking on accent bias fit with the firm's conservative posture. Amina resisted. She believed her work aligned with Title VII's purpose and EEOC enforcement priorities, especially as EEOC leadership publicly pledged to hold elite U.S. law firms accountable for bias across race and national origin. Then came a lightning strike. The EEOC formally opened a systemic investigation into the defendant corporation, citing her class complaint as a launching point. The agency began interviewing witnesses, requesting documents, and signaling that it may bring its own enforcement action if sufficient evidence of widespread discrimination emerged. Amina welcomed the development. EEOC intervention lends power and resources far beyond private litigation, but also raises the stakes politically. In current political climate, with civil rights enforcement under pressure, she knew the case could become part of broader debates over affirmative action, corporate liability, and protections for marginalized speech patterns. Just as Amina prepared for extended depositions, both public and private pressure escalated. The managing partner summoned her to a closed-door meeting. She arrived to find partners and ethics counsel waiting. They warned that if clients continued to threaten withdrawal, the firm might separate from her public-facing nonprofit initiative or even demote her internally. The meeting ended with a sharp message: "Your cause may be just, but our bottom line won't tolerate the risk." Heart-hammering, Amina stepped into an elevator, only to receive two simultaneous emails. One from the firm, Schedule firm ethics hearing regarding public engagement. The other from the EEOC investigator. Request. Would you be willing to testify before a federal oversight committee about linguistic discrimination? Her mentor had counseled public testimony might galvanize reform, but also likely provoke high-level blowback. Standing alone in that elevator, files in her hand trembled. She knew she faced a choice: retreat from public advocacy to preserve her legal career or stand firm and risk professional exile. But in both directions, the future of accent rights and racial inclusion in employment law hinged on her next move. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths. Once the EEOC notified her that it would pursue enforcement based on the pattern uncovered in her class action complaint, Amina Johnson found herself at the center of a seismic shift in employment law. The agency opened a systemic enforcement investigation into national origin and accent-based discrimination, grounded in EEOC guidance explicitly affirming that a discriminatory workplace environment because of accent, regardless of intelligibility, violates Title VI's protections tied to national origin and ethnicity. No longer just a private litigation, her client's stories now fueled federal intervention. Facing simultaneous fronts, her firm's ethics hearing demanding she temper her public advocacy, and the EEOC requesting depositions, documents, and testimony, Amina embraced her role as both attorney and civil rights trailblazer. She flew to D.C. for EEOC interviews, reviewing internal HR memos, deposition transcripts, and depositions where employers admitted preferring accents that fit a preconceived image of professionalism, language policing with racial overtones. She referenced cases like West Customer Management Group and Justice Department recognition that accent bias is a form of national origin discrimination, actionable under Title VII regardless of performance impact. She presented comparator evidence: white employees with strong regional or foreign accents retained or promoted, while Black and immigrant staff with similar or lighter accents were terminated, evidence supporting McDonnell-Douglas prima facie disparate treatment framework. Meanwhile, her firm's senior leadership circulated an ultimatum: scale back public commentary or face internal sanction. Yet Amina continued public lectures, law school panels, and media interviews explaining how accent-based bullying of Black and immigrant individuals is intertwined with racial exclusion, framing linguistic discrimination as rooted in harmful racial stereotypes, akin to historic bans on Black hairstyles like in Rogers versus American Airlines, where courts debated whether culturally rooted traits deserved Title VII protection. Across the country, legal blogs lauded her as initiating the voice civil rights era, demanding recognition that voice and accent carry racial and cultural meaning. As the firm's ethics hearing neared, Amina delivered her defense. Title VII not only forbids adverse employment decisions based on accent but prohibits the hostile environment created through accent mockery, humiliation, or exclusion, even if the accent did not impair performance directly. She argued that her public advocacy and representation aligned entirely with civil rights principles and statutory mandates, efforts to enforce, not violate, the law. She emphasized that customer preference for all-American-sounding employees cannot justify discrimination, a position supported by EEOC enforcement practice and legal precedent. Just as her ethics hearing concluded and the EEOC scheduled her testimony before a congressional oversight committee to testify on linguistic discrimination in the workforce, she received two explosive updates. One from the firm, the other from the EEOC. The firm's written ruling stated, "You are removed from public engagement role pending further review." Simultaneously, the EEOC elevated her to a witness status in a public hearing. She was asked to testify before Congress about systemic bias against Black and immigrant voices tied to accent stereotyping, the first time an attorney had been publicly called in such a capacity. She realized the moment had arrived. She could accept the firm's decision and retreat, or embrace the risk, amplify the issue nationally, and force legal and cultural change. She packed her notes for the congressional hearing, her nonprofit Voices of Justice announcement pending, and her firm dismissal letter awaiting review. She took a long breath in the silence of her apartment. She knew testifying meant possible separation from her firm, and potentially loss of her career, but staying silent meant letting the very discrimination she fought perpetuate. And as she stepped toward the microphone in the Capitol hearing room, flashlights, cameras, reporters waiting, she paused. The moderator introduced her simply, Amina Johnson, attorney and linguistic discrimination advocate. Across the room, faces turned. Lawmakers, civil rights leaders, firm representatives, and the public tuned in live. Her hand hovered over the podium microphone. Silence fell. Then she spoke. True justice sometimes demands that we risk everything we've built, not to benefit ourselves but to secure rights for others. Amina's journey teaches us that voice and identity are inseparable, and that when institutions ignore subtle discrimination, like accent-based bias, they erase human dignity and perpetuate racial inequality. Speaking up, even at personal cost, can reshape law and culture. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths.